so the judge understands all the issues. I'm going to brief all the issues so the judge is fully prepared to understand how to resolve it. What the case law says, according to me, and how the facts map in with the case law, and why the judge should rule in my favor. Then we go to a trial. A couple weeks. You can see that's another big expensive item. A typical patent case can go anywhere from $2 to $2.5 million. Big cases, you know, big companies have a budget of $80 to $100 million a year just to deal with patent litigation. It's an incredible amount of money. You can do things for less, obviously, if you don't argue every argument that could be made. And unfortunately, some attorneys like to argue every argument that could be made for fear of making a mistake or fear of not doing a good enough job, or, you know, just having an issue to fight about. That's a big number. So one of the things that we had talked about is how can we make this smaller, more cost effective. And well, pro bono, except, you know, I've got my bills to pay too, and it does take a fair bit of time. And I'll tell you, the pro bono work that I've already put in on this is a fair amount of time in sort of understanding the issues, coming up with a plan, selling that plan to my firm, selling the plan to the defendants, and trying to come up with a mechanism that makes sense for the developers, makes sense for their businesses, and, you know, has a reasonable chance of getting people out for a smaller amount of money. There's no sense for each one of you to pay $2 million per defendant to chase this suit to ground. But if we could make that a fraction, say if we, you know, in the Lotus case, if we were defending 40 defendants, same issues largely, lots of overlap. You look at the Venn diagram of the issues of those defendants, it is, you know, it's tight, right? Everybody has their own issues around the center, but at the end of the day, a lot of these things can be resolved with common pleadings, or forms that can be tweaked relatively easy, so not all the work is replicated. And this is what we had proposed to a group of the defendants in the Macrosolve situation. It remains to be seen how that all plays out, and we've learned a lot. Z and his group and some of the defendants have learned a lot, and we're going to keep chipping away at this until, you know, Womble's positioned to help the development community with these types of suits. But it's not a perfect solution, it's not an ideal solution, and with the aggregation there is you have to give up some control of the individual. Yeah?
With that amount of fee, do you guarantee that the defendant will win the case?
No. I wish I had the silver bullet, right, in this case. There's just no guarantees. You know, at the end of the day, this is a case that goes all the way through trial. A very small fraction. It's something I think the last data I looked at, it was between 90 and 95% of cases are resolved before the Barnaby Jones action, okay? So you can take off almost $1 million from that price tag in 90% of the cases. A lot more of them settle far earlier than that. So when we were looking at pricing this, we're not anticipating going to trial. We're anticipating we're going to settle long before the trial, because we're not going to spend that other $1.5 million to go to trial if it only takes us $50,000 to settle, right? So there is no guarantee. Unfortunately, I wish we could give guarantees, but we can't. The thing we can do is we look at these cases, we evaluate them, and we say, hey, this one looks like it's something that we could win relatively inexpensively if we could spread the costs across 10 defendants. It might make business sense for you to fight it as opposed to settle, right? You tip the scale in that cost versus settle, or fight versus settle analysis. Yeah?
Do any of the plaintiffs' lawyers take these cases on contingency?
Absolutely. And that's the beauty, and that's why the MPEs like this particular model. because they do take these cases on contingency. And if an attorney or a firm has, you think of it as a portfolio, right? They're going to spend 2,000 hours a year per attorney. They're going to spend, who knows, but certain portions of that are going to be winners for them, and certain portions of it are going to be losers. And there's a bunch that might finish off in the middle where they're break even. But at the end of the day, as long as your winners are exceeding the losers, then it makes sense, right? Same thing in your portfolios. Stock's going to be up one day, stock's going to be down. The hope is that the trend overall, you're making good money.
Two questions. You said you can knock off $1 million in 90% of the cases, so that's somewhere between $1 million and $1.5 million. How much of that, what percentage of that does the people who's actually bringing this suit, how much do they see it at? How much is he having proportionally? Are they spending that same amount to do this? The second question is, how much of that $1 to $1.5 million is actual billable lawyer fees?
So the majority of my stuff is billable. So I've put costs in here. Costs are about 10% of those.
So about 90%.
90% of my numbers are fees, attorney's fees. The other side is going to have similar costs in litigating, right?
Unless they're doing contingency, and then they don't have any incentive to. They're riding on the lawyers that have taken the risk.
Right. The other side, right. So the other business doesn't have direct out-of-pocket costs. Somebody does, but the attorneys who are taking the case have time costs. Right? They could be billing out as defense attorneys at $400 or $500 an hour. So there's an opportunity cost, but they're not, no one is writing checks. 10%, say 10% of actually out of pocket. They have similar costs. They have to pay experts. They have to, pay reproduction and copy costs and all that time, and have, people swipe their, or scan their systems for email and discovery and all that other stuff. They still have some hard costs. But it's not out-of-pocket costs paid to a lawyer in the same way. The law firm signs up to say, we will invest our time for a share of the proceeds. Yep.
I'd like to ask a part technical question, and I hope it's not a dumb question. And maybe more for you than anything else from the lawyer. And that is, if you have a form on the actual, mobile unit, or a form on your actual server that the mobile unit goes to, is there a difference?
I'll try.
And you get, and the person is putting the data on.
Well, I'll answer this really quickly. It doesn't matter. To what we're talking about, it really doesn't matter, because what I'm judging is either to figure out does it matter cost me a lot of money. So, I mean, there is a problem, right? There lies the biggest problem. So you as a developer, you tend to think, well, I say, well, we don't infringe because they're talking about Palm Pilot, I'm talking about iPhone. Fundamentally, it's different. Well, to prove that point, it's $500,000. So, I mean, I hate to be pessimistic here, but that is the situation that we need to deal with. All right, back to you.
Yeah. Go ahead.
Yeah, I'm curious here. So let's say I have a development firm. I'm a
Yep.
company here representing me, and you're giving me an estimate for how long the trial is going to be, how much it's going to cost, and now it goes way over, and I don't even have the money to pay your legal fees. What happens? Do I lose automatically?
No, you don't lose. You don't lose automatically. I mean, we couldn't. We try not to get in those situations, right? Either everything's an estimate. We try not to do fixed fee type stuff in big unknowns. In this case, we were trying to do a fixed fee. We were trying to provide this set of services. We'll take the risk. We'll take the risk if you're willing to take some risk too. If we get out cheaper, maybe we'll share some back. But that was at the end of the day. This is what you're going to pay this, and it gets you through this phase of the trial. This through Markman hearing. That was what we had proposed. But in a regular litigation, if something gets really contentious and you want to dig your heels, you can always say, no, I don't want to fight that fight. And you can tell your attorney, keep your attorney on a short leash and only fight the issues that matter. That helps you control your costs. But if you let your attorneys, just run off and well, you understand if you've engaged an attorney, you let them run off without being on a short leash, you're going to have a surprise bill at the end of the day. Not always, but.
Let's move on.
Yep. Yep. No, I have no more slides. This is just, I hope this is helpful just to kind of cast the problem.
Well, so Rick is not going away, so don't let him leave. Thanks a lot. So I'm hoping that this puts perspective, okay? It's not meant to send fear, but just put things in perspective.
We're on slide 1.
Yeah.
One important question though. So that's the cost if I want to fight it. What if I get the letter and say I'm just going to roll over immediately?
Well, yeah, you roll over whatever they ask. So now it's different, right? So in LOCIS, they ask for 0.575 of your revenue. So if you make $100 a year, that doesn't really matter. Now, so somebody in the blog says that, well, you don't underestimate that, because if you sign that 0.575, you now have to do like every month or every 6 months a financial to them, and they can audit your books at any time. So don't underestimate that. Yes. So yeah, let's take one more question before we move on for David. Yeah. Okay, forget about it. Anyone want to take that chance? Yeah, go ahead.
My question was, instead of defending everyone individually as they get sued, maybe trying to form like multiple groups each time of like 40 developers, why not just try to invalidate Lots' patent portfolio, or like the big ones, like spend that spend $4 million just destroying them so they can't go after anyone else.
That's what David is going to talk about in just a moment. One mechanism by which you can attack a portfolio. And so I'll let David go through, but there's issues with that, right? Some courts will recognize what's going on in the patent office to invalidate it, and some courts won't. Some courts will hold up the litigation while the patent office makes their validity determination, and some courts won't.
Like different states, or
different. I mean, it's not even just states; different jurisdictions.
If we're the aggressors, can't we choose?
If you're the aggressor and you file the patent office to invalidate it, it's called a reexamination. You can do that.
Right.
But the plaintiff could turn around and file suit against you in the Eastern District of Texas and insist that the litigation keep moving forward. So you've got these parallel paths.
What do you mean, file suit against me as a developer?
As a developer.
Right. What if I form just, I don't know,
So
what the
sue-
correct sort of
sue's a whole
NDP.
group of you.
Association.
Yeah, so I'll form an association.
501c3.
For what?
We're not developers. Well, I'm not developing anything here. We're just a group of people
Okay.
trying
Like
to
them.
destroy
You just want to attack bad patents. That's
Yes,
all.
I want to just like
Yeah.
crush them.
Then you're on the flip side of the MPE, and you're attacking patents, destroying patents.
Sure. Yeah.
Yeah,
Get
you can do that.
a
Absolutely.
Kickstarter page going. If this really is a bit widespread issue, everybody throws down $100. You get lots of money. You
Maybe
get to
$1,000.
be.
So actually,
$1,000 isn't my.
let me jump in, because this actually directly relates to what my company does. And so we're called Article 1 Partners, and what we've done is we've developed a online community that networks over 1 million scientists, technologists, average people worldwide to assess the validity of patents. And so I'm going to get to your point. I think that I like the way you're thinking.